This lady did it. She stabbed her mom to death in March 2020. Domestic violence is never right, and it's always wrong. Please take heed of others' mistakes. Domestic violence is never, ever right. She stabbed her mom to death, and it's not right. Now she's in court, and she's gonna have to face the music for what she did to her mom. Damn.
Good morning. Please be seated. All right, we are on the record in State of Ohio versus Sydney Nicole Powell. This is case number 2020-03-1008, scheduled this morning for sentencing. Present in the courtroom is the defendant with her attorney, Donald Malarsic. Present on behalf of the State of Ohio are Assistant Prosecuting Attorneys Brian Stano and Joseph McAleese. Present on behalf of the victims is Attorney Jeff Laybourne. Scheduled this morning, as I indicated, for sentencing. Mr. Stano, on behalf of the State.
Thank you, Your Honor. Your Honor, before the State makes its recommendation, customarily this would be the point in the sentencing where the court may or may not hear from the victims. At this point, I would defer to Attorney Laybourne as to whether any of the victim's family would be speaking at this time.
All right. I was going to do it between the two of you,
okay,
but I have no problem doing it right now. Mr. Laybourne.
Thank you, Your Honor. May it please the court. At this time, it's the wishes of the family not to speak. As the court is aware and the state is aware, many letters have been submitted on their behalves. They'd like the court to review those. We know that the court has, and we appreciate that. And other than what they would like to say through those letters, no one wishes to speak today other than myself. The tone and tenor of those letters, I think, is consistent with what the court saw throughout the trial and what the court continues to see here today, that they love and support Sydney no matter what. They will continue to love and support her, and they've been a consistent and constant presence in her life and in the courtroom, and that will continue as we move forward. They love and support her, and they're going to take care of whatever that she may need. It's no surprise the family is asking the court to impose the mandatory minimum sentence. I think that goes without saying, but we will say it anyway. Their bigger concern as we sit here today is that Sydney receives the mental health treatment and placement that she needs. We acknowledge, and I've explained to the family, that the Ohio Department of Rehabilitation and Corrections is in control of a lot of that. But to the extent that the court has purview or influence or can permit, we'd ask the court to permit her to participate in any mental health treatment or housing that may become available to her through the Ohio Department of Rehabilitation and Corrections. Specifically, there's a new mental health treatment center in Marysville, a 100-bed facility. Again, we understand that the court cannot place her there, but I know that they would appreciate a mention perhaps in the journal entry that any and all mental health treatment that would be available to her would be permitted and encouraged by this court. Just on a personal level, I think that a case like this exposes the tragedy of the legislature removing the discretion from judges like yourself, where you really only have a few limited options. I think that this is the type of case that would be ideal for the judge that has handled the case throughout and sat through the trial to use the discretion that we voted to give you to impose a sentence that would be more befitting the conduct and the wishes of the family and, quite frankly, the community. Lastly, Judge, I'd ask the court to consider waiving the court costs. Mr. Steve Powell posted Sydney's bond. We are all aware, for those of us that have tried jury trials, that after a trial with transportation and subpoenas and things like that, that the court costs can become significant. And we also are aware that those court costs would be deducted from that bond amount. So we'd ask the court respectfully to consider waiving the court costs in this matter. Thank you.
Thank you, Mr. Latham. Mr. Stano.
Thank you, Your Honor. Your Honor, I certainly understand that no one could feel the loss of Brenda Powell more deeply than her family and her close friends. And I certainly acknowledge their support for Sydney Powell. Your Honor, I do want to say, because I understand the court has gotten a lot of information from Brenda's and Sydney's close family and friends, that they do support her. Judge, I just also wanted to put on the record that our office has heard from a lot of other members of the community. And Brenda's loss is felt by the community as a whole. And a lot of those community members have, in fact, reached out to our office as well. I'm not going to repeat everything they've said, but I do want to at least note that there is a large part of the community that does feel that justice was served in this case, and the jury did get it right. And the sentence the court has imposed will reflect justice in this case. I certainly understand there are conflicting views in this case. There were during trial, and there will be for a very, very long time. That said, Your Honor, what the state is requesting at this time, certainly the murder counts are 15 to life. There is no discretion in that, as the court and counsel are well aware. Your Honor, we are asking for first, the felonious assault. The state is not conceding that will emerge. That is certainly within the court's discretion and view. We are asking for an additional 3 years on the tampering charge, Judge. We believe that Ms. Powell's behavior in staging the scene certainly warrants an additional sentence. So we are asking for 3 years on that count for a total of 18 to life. Your Honor, the state's recommendation isn't based on any ill will or vengeance or disregard for the Powell's family's wishes. At the end of the day, Your Honor, while we always do our best to take into account victims' wishes, we represent the community as a whole. And we also try to be consistent with our recommendations, Your Honor. And there are, as this court's aware, this court sees murder cases. All 10 judges in this courthouse see murder cases tragically every year. Akron police alone they consistently average 20, 30 murders a year. And the state feels the sentencing recommendation is a fair one because not every murder defendant has the support Ms. Powell has. But at the same time, the state needs to be consistent and fair to everybody when it makes its sentencing recommendations. We believe, based on the facts of this case, the jury's verdict, the jury has spoken, and we believe a total sentence of 18 to life is appropriate under the facts of this case. Thank you.
Thank you, Mr. Stano. Mr. Malarsic.
Thank you. Your Honor, we are asking this court for the minimum sentence of 15 years to life, and I just want to briefly address some of the issues that Mr. Stano has brought to the attention of this court. First of all, there's the merger issue. I would respectfully submit to the court that the case law fully supports that the felonious assault conviction does merge with one of the two or both of the murder counts. They are allied offenses of similar import. I think the court has heard all of the evidence in this case, and I don't think there's any evidence of any separate animus that was committed between the felonious assault as well as the murder convictions. You have heard the undisputed evidence that the acts of the felonious assault were identifiable blows to the head and stab wounds, and I don't My recollection, Judge, is that I think Dr. Schott had testified that either of those could be fatal, either the blows to the head or the stab wounds. They were obviously all committed and proximately caused the death of Brenda Powell. They were all done at the same location. They were all done within the same period of time. And again, I don't think there was any evidence at all of any separate animus such that they should not merge and would support lawfully a separate sentence. Judge, I know this court is very much aware of the purposes of sentencing in the state of Ohio, and they are to promote the effective rehabilitation of the offender using the minimum sanctions necessary without an unnecessary burden on the state. They're also to protect the public and prevent future harm. And there are factors that this court, I know, will consider and has considered, and those factors determine whether or not this offense is more serious than other offenses committed and sentenced for the same conduct. And I would submit that a number of the factors that this court must consider pursuant to the legislature are not present with respect to more seriousness. We know that it was not Brenda's physical or mental condition or age that facilitated this offense. We know that Sidney Powell did not have any position of public trust, occupation. This was not an offense for hire. This was not an offense that was motivated by race or gender. And I think when the court looks at the factors under 292912 that determine whether or not this offense is less serious than the types of offense that get sentenced, there are a number of factors there that support a minimum sentence, namely that there was strong provocation by Sidney and that there are substantial grounds to mitigate Ms. Powell's conduct, although those grounds are not enough to constitute a defense. Obviously, this court heard from and the jury heard from 4 separate expert witnesses that the defense had brought forth, and although the jury did not feel that this rose to the level of not guilty by reason of insanity, I don't think that there's any dispute that, and the government said in its opening statement, and I believe closing arguments, that Sidney Powell's mental health had some impact on the consequences and the conduct in this case. So I think when considering those factors, this is less serious than some of the murders that Mr. Stano is trying to lump Sidney Powell and her family into. When the court considers whether or not Ms. Powell is less likely to, or is more likely to commit future offenses, I think nearly all of those factors weigh against the likelihood of any future offenses being committed. Ms. Powell has never been adjudicated delinquent as a juvenile. She has never been convicted of any previous offenses. She has never demonstrated a pattern of drug or alcohol abuse related to this offense, and I think she has shown genuine remorse. And I think that was borne out not only by the experts who testified, but also by Betsy Brown and Stephen Powell and others who testified who know Sidney well. When you look at the factors that determine whether or not an offense is less likely, an offender is less likely to commit a new offense, nearly all of those factors, I would suggest, apply here. And that is, prior to committing the offense, Sidney Powell had not been adjudicated a delinquent child. She had no prior criminal record. She led a law-abiding life up until this event, and there were the circumstances under which this event occurred, which is untreated serious mental disease, have been remedied. We know that Sidney Powell has been out on bond for 3.5 years. She has done better than perhaps any client I've ever had over 30 years as a criminal defense attorney while out on bond. You heard evidence that she never missed a dose of her medication. She looked forward to counseling. She abided by each and every one of this court's conditions that would keep her in the community. We never had any concerns or issues brought to this court by pretrial services regarding Sidney's behavior. And then lastly, under the factors that determine whether a consecutive sentence is warranted or necessary, I just do not believe respectfully that the law would support consecutive sentences that Mr. Stano is asking for. And those 3 factors are, number 1, to support a sentence of consecutive sentences, whether the offender committed one or more of the multiple offenses while the offender was awaiting trial or sentencing. That obviously is not present here. Whether 2 of the multiple offenses were committed as part of an additional course of conduct. This was all one course of conduct. I believe that's undisputed. And whether or not the offender's history or criminal conduct demonstrates that consecutive sentence are necessary. And then finally, I know that this court must also consider the wishes of Marcy's Law and the wishes of the victim, and they have been repeatedly ignored by Mr. Stano in this case. I think the court knows that. We had a hearing on that prior to trial. Both Stephen and Betsy urged this court to not proceed with trial. They made their wishes known, and those wishes were rejected. So now at sentencing, there is this opportunity for Mr. Stano to give some grace and deference to the victim for the suffering that they have endured in the last nearly 3.5 years. And unfortunately, that opportunity is rejected. Just the idea that they would simply ask this court to impose the minimum sentence and not run the tampering charge consecutive. The fact that that is ignored and the wishes of the victims are trampled upon yet again, I find appalling. So I would ask the court to impose the mandatory minimum 15 years to life. And I would also indicate what Mr. Laybourne said, and you have a number of letters from people in the community. It's easy for Mr. Stano to reference anonymous people in the community who don't want to be heard, who don't put their name to a letter, who don't come into court and testify. I've gotten dozens of emails full of rage and vitriol and hate and anger from anonymous members of the community that want to see Sydney receive the death penalty. That's not what we listen to. The Constitution demands and compels that we listen to the people who are most affected by this crime, and those are the individuals back here in this courtroom. That's who Mr. Stano should be listening to. He should have also read the letters that I submitted from the members of the community who were courageous enough to put their name on what they are asking this court to do. And what you saw in those letters from the community are letters from police officers, letters from a teacher, and you heard from a teacher in this trial, letters from a doctor, from lawyers, from people who work with Brenda Powell for almost 30 years. Those are the people in the community that I would urge this court to consider the opinion of, the people that know this family well. I would ask the court, as Mr. Laybourne had indicated, to do whatever you can in the journal entry to ask the Department of Corrections to consider giving Sydney a bed at the new Reformatory for Women mental health facility. I know that this court is very limited in what you can do, and this will be up to the Department of Corrections, but I would ask the court to consider doing that. Your Honor, for purposes of moving forward, I know you're going to advise Ms. Powell of her rights to appeal. I have done that as well. I believe that Ms. Powell is indigent given the sentence that this court will impose. I would ask the court to appoint appellate counsel for her, and I would join in Mr. Laybourne's request to waive the court costs and consider doing that in this case, given that Mr. Stephen Powell had put up the bond in this matter. And I would just end with, I think, a letter from a doctor from the Akron Children's Hospital that really sums up what I believe are the overwhelming sentiments of not only the victims under Marcy's Law, but our community. And that doctor said, and I quote, "I've almost never felt so strongly that I need to offer a voice of advocacy as I have in this tragic situation of an unfathomable verdict and the tragic current of ripple effects that will undoubtedly have upon this loving family. I have repeatedly heard from those who know Brenda well, their intimate knowledge of Brenda, her family, her husband, and Sydney, that they have endured incredible loss as a result of Sydney's actions on that horrible day. Even so, it is literally beyond words and many people's comprehension how tremendously loving they have been and remain towards Sydney in their clear knowledge of her mental illness and impairment, and the powerful clarity that Brenda herself, if she were still alive, would without a doubt want the unwavering support of Sydney's continued treatment for her mental condition in the least restrictive environment possible, with as much family connection and contact as is possible." That's our community. Those are the people that know this family well. not some anonymous person who contacted the Summit County Prosecutor's Office and supposedly spoke to Mr. Stano, not some amorphous thought of the community. The people who know this family, the people who know Brenda, the people who know Sydney are all asking this court to consider the constitutional wishes of the victims and impose a minimum sentence. Thank you, Your Honor.
Thank you, Mr. Malarsic. Ms. Powell, is there anything you want to say to me at this time? Okay.
I have advised Ms. Powell that given the nature of her appeal, she should not make a statement today.
And I understand that, but I have to give her the opportunity to do so. All right. Thank you very much. First of all, to the victims, to the family and friends, I am terribly sorry for your loss here. I cannot imagine what you have been through. I have received and read all of the letters that have been sent to me. I have considered the evidence that was brought into evidence at the trial, the statements of counsel, and all of the information that is before me at this time. I do find that counts 2 and 3 merge with count 1 for purposes of sentencing in this matter. Based upon the facts and circumstances of this case and in consideration of the relevant sentencing factors, including seriousness and recidivism, and applying the minimum sanction that the court has determined will protect the public and punish the offender without imposing an unnecessary burden on state and local resources, the court imposes the following sentence. On count 1, ma'am, I sentence you to an indefinite sentence of 15 years to life in the Ohio Department of Corrections. On count 4 of the indictment, I sentence you to 3 years in the Ohio Department of Corrections. Those 2 sentences to be run concurrent with and not consecutive to each other. Ma'am, please understand that on count 4 of the indictment, you may be subject to a period of post-release control upon your release. And if you violate that post-release control, the Adult Parole Authority is authorized to return you to prison for up to 9 months for any single violation and up to 50% of your prison sentence for all violations. Please also understand that if you're placed on post-release control and you are convicted of a new felony, in addition to being punished for that new offense, the judge could add an additional consecutive 1-year period of time in prison, whichever is greater, as a maximum. Ma'am, understand that you have a right to appeal this decision, and that notice of appeal must be filed within 30 days of the sentencing judgment entry. Your attorney has indicated to me that you are without funds to hire an attorney to represent you for appeal. Is that correct? And you wish for me to appoint counsel to represent you? Yes, sir. All right. I will do that, and we will try and get that done before you leave the Summit County Jail. Ma'am, I will not fine you. I will not assess you court costs in this matter. Counsel, is there anything that I have forgotten?
No, Your Honor, and I neglected to do this earlier, and I apologize. We appreciate the court's deference to Ms. Powell and the opportunity to allow her to lead during certain portions of the trial. I know that it is rather unprecedented, but we really appreciate the court's compassion in allowing that during this trial. Thank you.
Thanks are necessary. Good luck to you, Ms. Powell. Thank you. We're adjourned.
All rise.
God bless the mom, and God bless her family. Thanks for watching. We appreciate you. Please subscribe.